Any measure? One matter, as is mentioned, mandate. This is to come from the Calcutta. So it has not been listed today, probably because the records have gone. Or maybe it will come today, then may it be listed tomorrow or not, because I am here.
Take steps. Yes, sir. Okay. The final of
Agree.
Your Lordship, this is a case for contempt matter, and the matter was TK number 34 of 2025 in WPC 663 of 2012. Your Lordship, this case was taken up by the Honorable Justice Shubham Singh and Justice Prasenjit Mandal. Your Lordship, Justice Prasenjit Mandal has retired, and Honorable Justice Shubham Singh, he has been transferred and appointed as a Chief Justice of Meghalaya. I would humbly say before the Honorable Court that this matter may be done by this way.
Yes, so what? Yeah. File is lying
Your Lordship,
In the principal seat.
we have to got from the principal being thereafter we can make a list.
I'm told the file is in the principal seat, so we'll have to call for the records.
Number on. This is the code of 925.
I was severe pain in my throat. Can this appeal be taken on Monday?
Okay.
Monday, I have some difficult.
Any date which.
Tuesday, Wednesday,
I haven't called.
This is available on Thursday.
Thursday, fine.
Next week.
On request made by the learned counsel for the applicant. List on Thursday is what date? 27th. Okay. In short, the practice for this one is.
Take up 925. My lord, I am appealing for the appellate, my lord. This is a second appeal. This is the substantial question of law, my lord.
Two issues. Part so and so, counsel for the applicant. After hearing the learned counsel for the applicant, the following substantial questions of laws are formulated. Admit normal also, 4 weeks.
For day of the proceeding. Can one.
Where's can one? This.
No.
Yes.
It's there.
Department.
Wait for some time.
Number 3. Remedy 31 of 2025.
This will be taken up on Monday.
Monday, 24th.
I'm grateful.
Item number 1. Remedy 44 of 925.
I've checked it, but the registry it has been filed.
No, you are 40?
I'm for the appellant, Malam.
Let us see the records. Have you saved copies?
My lord?
Have you served copies?
Yes, my lord. I have served. I filed the affidavit service.
Okay,
With regard to respondent number 1, 2, 3, and 4, uh, they have been served by hand, not through the Pune book. I have enclosed the Pune book and the endorsement. Respondent number group, it has been sent through speed post. No, the track report has been enclosed.
Respondent one,
Mr. Kurup, my lord, page number 4 of the affidavit service. The speed post receipt and the track report is the next page, my lord, 4 and 5.
they have a state council here, or they don't have. Here, this union. Oh, okay, okay. Oh. Respondent. Only one respondent.
No, but there are other respondents because the Deputy Commissioner, Car Nicobar, South Andaman SDO of Camel Bay, Police Station of SHO Camel Bay, and Tahsildar Camel Bay. They have been served through Pune book, my lord, and the endorsement in the Pune book has been enclosed.
Correct. How do you finish?
Page number 8, my lord.
Oh, these are the performer respondents.
Yes, yes, my lord. Because
Okay, but the main respondent is the.
is the Kurup, my lord. He is being a respondent number 1.
No, see, your what you call
Receipt, my lord.
numbering is not proper. There's no number for the main respondent.
I understand. I will permitted to correct it, my lord, because 1, 2 it has to be started, but instead of that, the performer has been started as well.
Correct it now. I've told the correct it. Normally, what you do. Why don't you correct it now so that
I will correct, my lord. During the process.
in both the copies?
Yes, yes.
By putting your initials. Give him copies, correct, correct the men. Even in the can also same. Affidavit of service. Oh, okay, fine.
Let it come tomorrow, my lord. During the course of the day, I will do correction.
Okay,
Okay.
tomorrow.
Yes.
You make the corrections
Yes.
by putting your initials.
Obey. Lord, I am for the respondents, my lord. My lord, as this matter, council used to appear from the virtual mode. My lord has fixed it today because
Any
yesterday nobody has
Any
appeared.
request for VC? We don't have cases, no? For next week, we don't have. Okay, none appears for the appellant. Mr. So-and-so appears for the respondents. Please again on. We'll try next week. 25th.
Obey. No, I am for the appellant, ma'am.
But I am for the sole respondent. It's matter is hanging fire, there is an order of the learned tribunal, not, they have challenged that order and it is perhaps not maintaining, but let them make submission.
But this is an appeal arising out of a judgment passed by the tribunal. Not in compliance to the earlier order passed by this court, we have to issue the provisional pension, and that has been issued, and an explanation to that effect has been filed. Perhaps sir has not. I'm sorry, but sir was not there, so I copy. So that they will receive the amount, I suppose, if they have not been denied it to
We are
them.
not on that, because the petition requires to be finished off today itself, because we are unnecessarily pending. Very short point, let them make submissions, I will wait, 2 minutes subject to your document.
Lordship, the respondents herein, being an NFSG as a being a doctor, he was posted to Mayabandar, and he was as a medical officer at that point of time. He has floated certain tenders for purchasing medical equipments. In that, discrepancies are found, and there is a misappropriation of fund has been found, and the charge sheet has been issued in 2015 and 2016. Both the two simultaneously two proceedings. One is misappropriation of a source of income, and another is with regard to the tenders, floating of tenders. He has not followed the norms, and due to which a loss to the government exchequer. So they have issued a charge sheet. Due to the pendency of the charge sheet, he is not able to give a promotion to be as a director. The matter went to tribunal, then went to High Court, and went to ultimately to the Supreme Court. Not the first order of the Supreme Court, because the facts with regard to the promotion is not relevant to the present case. Because the only aspect is whether the punishment order passed by the disciplinary authority after his retirement in terms of the CCS pension rule section 9, the appointing authority being as a disciplinary authority, the honorable lieutenant governor has a very limited scope, because he has to conclude the disciplinary proceeding. It has to be sent to the MHA. After the concurrence from the president, only the president can impose punishment in consultation with the UPSC. So the lieutenant governor being a disciplinary authority, he concluded, he sent to the president, and president has passed a penalty order. The only grievances before the tribunal is that whether in terms of the Supreme Court's direction was given to within that period whether the disciplinary proceeding has been concluded or not. The tribunal has said as the Supreme Court direction, it was not concluded. So the disciplinary proceeding which has been passed by the President of India has to be quashed. Against that order, we come before the Lordships challenging the order passed by the tribunal. This is a brief facts, my lord. I just take my lord's kind attention to the first order of the SLP. My lord, it is at page number 89, my lord. Lord, I'm permitted to read, Lord, page number. I just take Lordship's kind attention to page number 91, second paragraph.
Yes.
By the impugned common judgment, the Honorable High Court affirmed the direction of the tribunal dated 5th January 2016. In fact, when the writ petition was pending, there was an interim order passed wherein the Honorable High Court observed that nothing prevented the concerned authority of Andaman Nicobar Islands administration from considering the question of grant of current duty charge to the Director of Health Service, Andaman Nicobar Islands, Port Blair, in favor of the petitioner, even without giving any financial power and reserving such power to be used by the authority superior to him upon taking into consideration the fact that he had few days to go before his retirement from service in the month of March 2016. In fact, the retirement of the petitioner will occur on 31st March 2016. When we heard Colonel R. Subramaniam, Lieutenant Counsel appearing for the administration of the Union Territory, he brought to our notice the pending disciplinary proceedings against the petitioner, which pertains to the allegations of non-intimation of acquisition of movable properties such as purchase of shares, creation of fixed deposits, grant of loan, etc. He also fairly brought to our notice that when in the incident the Union Territory a complaint was preferred against the petitioner, the police submitted the final report being number 26/2014, dated 19 November 2014, in the Court of Chief Judicial Magistrate, Port Blair, with an observation that no charge sheet for want of evidence. However, the report listed about 8 instances which created suspicion as regard to certain intimations claimed to have been made by the petitioner as regard to acquisition of 3 these immutable properties. There is also another disciplinary proceeding initiated against the petitioner in the month of March 2016, pertaining to same irregularities in purchase of certain equipments while working as a joint director, Health, North and Middle Andaman Medical Officer, Superintendent Dr. R.P. Hospital, Mayabandar from April 2013 onwards. Colonel R. Subramaniam would contended that in the light of the approved disease proceedings and even while complying with the order of the tribunal, appropriate DPC will have to be constituted and based on the outcome of the said proceedings. The petitioner's claim for grant of SAG would be made and thereafter for being posted as a director of health services. The understanding council for respond would thereafter contend that it may not be appropriate in this stage to consider any posting of the petitioners even on off basis in the post of director of health service. Mr. Sujit Samanta, Land Council appearing for the petitioner, earnestly submitted that petitioner was deprived of his chance of holding the post of director of health services under some pretext to or the other. That the initiation of the received proceeding related to the concurrence of year 2013 and alleged disclosure of the immovable properties pertaining to the period 1997 were all initiated solely with a view to deprive the petitioner from becoming director of health services, taking advantage of the fact that the petitioner service is going to be end on 31st March 2016. Having considered respective submissions, we are also convinced that the grievances expressed the petition are genuine, while at the same time, it may not be appropriate for this court to reach a definite conclusion that the disciplinary action initiated against the petitioner are not based on any materials or not supported by any material evidence. In such circumstances, justice can be subserved by directing the responsible administration to pass an order appointing petitioner purely on ad hoc basis and by posting as the in charge officer in the post of director of health services of Andaman Nicobar Islands progress so that the ultimately retired in the said post position subject. However, the outcome of the disciplinary proceedings already issued against him in charge sheet dated 4th March 2015 and in one dated 2nd March 2016, as well as the outcome of the DPC proceeding under the recruitment rules of 2013 as directed by the tribunal, as affirmed by the High Court. For that purpose, it will be permissible for administration of to keep the process of retirement of the petitioner behind 31st March 2016 pending, and also by not allowing him to retire by applying the rules providing any such course to be adopted. We only direct that in the first instance, the Union Territory of Andaman Nicobar Islands to proceed with the disciplinary action after getting the reply of the petitioner to the respective charge sheets, with the petitioner shall submit within 4 weeks from today and conclude the inquiry proceedings within 3 months from today. So this is the first cut-off timing prescribed by the Supreme Court. Miller. Depending upon the outcome of the decision proceeding and the final orders to be passed, it will be open for the responding Union Territory to proceed with the DPC as directed by the tribunal under the recruitment rules of 2013. Again, depending upon the outcome of the said proceeding, in the event the petition being eligible for SAG and consequent promotion to the post of director of health services, the temporary charge posting issued to the petitioner as director in the order shall be confirmed in his favor, and whatever benefits occur him based on the such final orders to be passed shall be granted. In the event the petition not becoming entitled to get the promotion as a light of based on the outcome of the disciplinary action as well as the DPC proceeding under the recruitment rules of the government, it is needless to state that the whatsoever consequences that we should follow will subject our entitlement and petition to work out his remedies in the manner known to law. Therefore, we direct the Union Administration to forthwith pass orders posting the petitioner as in charge in the post of Director of Health Service, Andaman Nicobar Islands, till he reaches the supervision. Even while passing such posting orders, Union Territory can make it clear that he will not be empowered to exercise any powers of monetary liability, and he shall not deal with files pertaining to disciplinary action issued and pending against him. We are confident that the London Standing Council of Administration will give intimation to the concerned authority, comply the orders relating to the posting of the petitioner as a director in charge, as a director in the office without further loss of time. Now, based on this, next page is a 98. In compliance to that order, my lord, on 30th March 2016, in compliance, my lord, got it, my lord? Page number 98, my lord. In compliance with the terms of the Solomon 2016, on the Supreme Court of India, passed in special leave appeals so and so. Lieutenant Governor is pleased to transfer Dr. R. Tulsidasan, CMO NFSG from Dr. RP Hospital, Mahabandar, and post him as an in-charge officer in the post of Director Health Service, Andaman Nicobar Islands, till he reaches the age of superannuation, that is 31st March 2000. However, Dr. Tulsidasan shall not exercise any powers of modified liability, and he shall not deal with files pertaining to disciplinary action issued and pending against him. But as such, the disciplinary proceeding which is not been able to conclude within this stipulated period of time given in the instant order passed by the Honorable Supreme Court, the petitioner, the respondent herein, filed in contempt before the Honorable Supreme Court. My lord, that order starts from page number 100, my lord.
No.
How about page 99?
After the 100.
Probably my learned friend is, but what happened is, they took extensions. If your lordship comes to the list of dates, it's better. Lordship kindly comes to page 40, the short list of dates. 40.
Yes.
Lordship has got it, Lord. 29/3/2016 is the order which my learned friend just now read out. Then, my lord, 31/3, the applicant superannuated. 5/8, there was an extension granted by the Honorable Supreme Court, 3 months. Then 5/12, another extension by 3 months. Then 10/4/2017, another extension by 3 months as last chance. And 4/9/2017, MA filed for extension was refused. 4/9/2017. Sorry, not refused.
No,
Extended by
extended.
6 months.
6 months.
As the last chance. Again, I'm sorry, I stand corrected. Then, Lord, next page, 18/9, we issued a notice of contempt. That is not relevant. Next, 14/5/2018, IA for 4 months extension was rejected. That is the first rejection that you cannot extend the proceedings any further. Now, Lord, thereafter, the proceedings continued. I will not waste your lordship's time. Lordship kindly comes to.
No, let me.
Please.
I'm sorry.
Please.
I stand corrected, not because thereafter a series of extension, because after the contempt, the scenario has been changed. That's why I don't want to trouble your lordship to the other orders. The state I come to the contempt orders, not because that is at page number 100.
In the list of dates, it's 3/12/2020. That is there.
I'm thankful, my lord, that my brother has stand corrected over that facts. But my lord, may kindly come to the page number 100, my lord.
Yes.
Lord, this is an contempt they approved before Supreme Court, saying that as per the timelines prescribed, which was extended time to time, the department proceeding has not been concluded. So they reached to the Supreme Court filing a contempt. Lord, the Supreme Court, while deciding the contempt, may kindly come, my lord, the order I start, my lord, with regard to page 102, my lord, para 4.
Yes.
Lord, second paragraph, inner page number 3. Thus, the above judgment of this court, a period of 3 months was granted to conclude the disciplinary proceeding. In the meantime, there was a direction to issue an order of posting the respondent as a director of health services and on ad hoc basis till they attain the age of superannuation. In pursuance of the liberty granted by this court, the disciplinary proceedings were initiated prior to his retirement were continued against the respondent after his retirement on 31st March 2016. Since the period of 3 months was fixed for conclusion of disciplinary proceedings, application for extensions were filed by the administration of the Union Territory before the court. An extension of time to complete the disciplinary proceedings were allowed on 5 August 2016, 5 December 2016, 10 April 2017, and 10 December 2017. On further application, extension of time was refused by an order dated 14th May 2018. Now, the sequences have been enumerated by the Honorable Supreme Court. The respondent then moved the Central Administrative Tribunal seeking the challenge and order dated 25 February 2000 passed by Chief Secretary of Andaman declining to release his service benefits. According to the respondent, the department proceeding could not have been pursued after the order of the court. And on 14th May 2019, this OA was occasioned by the fact that after 14th May 2018, enquiry reports were submitted by the enquiry officer on 14th September 2018. And 18 September 2018, the tribunal by its order dated 5th February 2020 dismissed the OA and allowed the administration of Andaman and Nicobar Islands to continue with the two departmental proceedings by extending the time by a period of 3 months. This order was challenged before the Calcutta High Court by a respondent under its writ jurisdiction by a judgment and order dated 2nd March 2020. A division bench of High Court allowed the petition. The High Court held that once an extension time is concluded, the disciplinary proceedings have been refused by this court on 14th May. It was not open to the tribunal to pass an order of extension of time. Consequently, while setting aside the order of the tribunal, the High Court caused the disciplinary proceeding and directed the release of all service benefits, including pensionary benefits to the respondent. This is, however, the matter has travelled to the court at the behest of the administration territory of Andaman and Nicobar Islands. During the pendency of this proceeding, an application was filed by the administration for recalling or modifying the order dated 14th May 2018 passed by this court and for extension of the period for completion of the disciplinary proceeding by period of 8 months. Ms. G. Indra, Learning Council appearing on behalf of the appellant, submits that the enquiry was initiated validly by the issuance of charge sheet prior to the date of retirement of the respondent. It was urged that in terms of Rule 9 of Central Civil Service Pension Rules 1972, the enquiry should be continued and concluded after his retirement. Learned Counsel submitted that this was the basis of the judgment of this court in earlier proceedings when 3 months' time was granted for conclusion of disciplinary enquiries. Learned Counsel submitted that the reason why there was a delay on the part of administration in concluding the enquiries was not attributable exclusively to the enquiry officer, but as the annexures to the application would indicate, there was a continuous non-cooperation on the part of the respondent in the disciplinary proceedings. Learned Counsel submit that as a matter of fact, the enquiry stands concluded and enquiry reports have been submitted to the Union Ministry of Home Affairs, which is termed as more the UPSC Commission for seeking advice. In this background, it was urged that the consequences of the order of the High Court would be stultify the enquiry proceedings and it would be interest of justice to allow these consequences. When an enquiry has been held into allegations implicating a major penalty, an extension of time has been sought complete the proceeding by recalling or modifying the order dated 14th May 2018. One on the other hand, Mr. Sujit Samanta, Learned Counsel, appearing on behalf of the respondent, submitted that by the order of this court, 3 months' time was granted to conclude the disciplinary proceedings. He submitted that upon the application filed by the appellants, the court extended time on 4 occasions and ultimately on 14th May 2018 declined to allow a further extension. Learned Counsel submitted that while opposing the application for extension, the respondent stated on affidavit that during the previously extended period of 6 months, only one hearing had taken place before the enquiry officer. Learned Counsel submitted that the disciplinary proceeding could not have been held after the refusal of this court to the extent time on 14th May 2018, and in consequences, the disciplinary proceedings are void and unenforceable. Having regard Learning Counsel appearing on behalf of private parties, it must be noticed at the outset the disciplinary inquiries were initiated prior to the retirement of the respondents from service on 31st March 2016. Consequently, in terms of Rule 9 of Central Civil Service Pension Rules 1972, the inquiries could have been continued after the date of his retirement. Rule 9 read as follows. The Rule 9 has been quoted by the Honorable Supreme Court. The Rule 9, the right of President to withhold or withdraw pension, it pertains to the sole domain of the President. May kindly come to that page 106, 5th paragraph. 106, 5th paragraph. Provided there were department proceedings are initiated by an authority subordinate to the President, that authority shall submit a report recording its finding to the President. Here the Lieutenant Governor being as an authority who is a disciplinary, he has to record he has to submit it to the President. The department proceeding is initiated while the government servant in service, whether before his retirement, during his re-employment. So this is not I just read the provisional clause because it clearly says that once if a person has been retired, then an inquiry has to be submitted, a report has to be submitted to the President. Para 11, 107, para 11, page number 107, para 11. 107, I just take note the powers of the President to what extent they can impose punishments. Para 4 and para 5. Page number 107, inner page 8, para 4 and para 5. In case of the government servant who has retired or attaining the superannuation otherwise against whom a department proceeding or judicial proceedings are instituted, where department proceedings are continued under rule 2, a provisional pension as provided in rule shall be sanctioned. That has been sanctioned not because he has got the provisional pension. Whether the president decide not to withhold or withdraw pension but order recovery of peculiar loss of the pension, the recovery shall not orderly made a rate exceeding one third of the pension admissible on the date of retirement of the government servant. So if it concluded that he has been found to be guilty with the charges, then that one third of the pension admissible on the date of retirement of a government servant has to be imposed as a punishment. So, note para 11. The dispute which had travelled to the court in earlier proceeding related to claim of the respondent for promotion as a director health services, the judgment of this court noticed the disciplinary inquiry has already been initiated. The inquiry was validly instituted prior to the retirement of the respondent. Now, the Supreme Court has taken the stand that the inquiry which has been started, it was prior to his retirement, so it is a validly the inquiry has been initiated. Hence, the judgment advised that the final decision of the substantive promotion of the respondent would be depend upon the outcome of the disciplinary proceeding. The point to be noted is that there was no legal embargo on the continuance of the disciplinary proceeding which had been instituted prior to the retirement of the respondent from the service. Originally, in the order of this court dated 29th March 2016, a period of 3 months was sent down for concluding the disciplinary proceeding. This time limit is must be understood was not a statutory fixation of a fine under the service rules, but was in the background of a claim of the respondent that he was being denied promotion to the post of Director of Health Services. The purpose of setting out a time limit was to facilitate an early decision on the claim of respondent to promotion, since it was upon the outcome of the disciplinary proceeding that the decision on the claim of respondent would be conditioned. It was the background of that this court observed the respondent promoted initially as in charge officer in the post of Director of Health Services, that inquiry be concluded within a period of 3 months. And subject to the outcome of the inquiry, a final decision would be taken on the promotion of the respondent. Undoubtedly, the Union Territory was unable to conclude the inquiry within the period stipulated. However, the disciplinary proceeding cannot be quashed merely on the ground of delay. The nature of charges, the circumstances surrounded by the delay and conduct of the parties may such that it would not be in interest of justice to quash the proceedings. So, but the Supreme Court has said that the delay it cannot be judged because the other circumstances and other aspects has to be taken into consideration. But the Honorable Supreme Court has read upon two judgments from the state of Punjab versus Chamanlal Goyal that principles have been quoted. I will not trouble them a lot to that extent because the other side will deny to that extent. Para number 13. It would be opposite to carefully evaluate the reason for the delay, including the conduct of the parties, Indian Overseas Bank, Anna Saleh and others versus P. Ganeshan and others. The employer against whom a disciplinary inquiry was being conducted kept on seeking adjournments, which was allowed by the concerned inquiry officer. The employees were also simultaneously subject to criminal proceeding. The move of the High Court of Madras under its writ judicial say the decision was in until criminal cases are decided, which are followed by the court. This court, while setting such judgment of the High Court, observed furthermore the discretionary writ jurisdiction under Article 226 of the Constitution of India should be exercised keeping in view of the conduct of the parties. Respondents made a representation that in the event the order of suspension is revoked, they would cooperate with the inquiry officer. They kept on filing applications for extension of time, which were allowed. They took benefit thereof without, however, following show cause. The move of the High Court, furthermore, before the inquiry officer also noticed here in before. Although they had appointed the defense counsel, did not cross-examine the witness, examine on behalf of the management. A large number of witnesses have already been examined on behalf of the appellants. The disciplinary bench, as well as we have noticed here and above, have proceeded to a great extent. In such situation, we are of the firm view that discretion jurisdiction should not have been exercised in favor of the respondent 1 to 4 by the High Court. It is also relevant to consider if a satisfactory explanation has been provided for the delay in concluding the departmental inquiry in Bharat Coking Coal Limited versus by Bibiti Kumar Singh and others. This court stated, we are of the view that the considering the seriousness of the charges and explanations offered by the appellant for delay in concluding the inquiry, which cannot be said to be unsatisfactory, the fact that the inquiry has been processed to some length, the High Court ought not to reject the reasonable prior appellant for extension of time. Relevant correspondence and order of disciplinary proceedings have been annexed to the application filed by the administration for extension of time and recall modification of the order dated 14th May 2018. The record indicates that there were changes in the inquiry officer as a result of their transfer or reposting. More significantly, the respondent himself did not cooperate in the. This is the observation that I'm just reading. More significantly, the respondent himself did not cooperate in the conclusion of the disciplinary proceeding, and his conduct was responsible in large measures of the delay. For instance, as and by the way of illustrations, upon being informed by a letter dated 8 September 2016 of the appointment of inquiry officer, responded by his letter dated 9 September 2016 stated that he was not bound to appear unless he received an original copy of the order of the Lieutenant Governor appointing the inquiry authority. On 24/16 October 2016, the appointment order was forwarded to the respondent. On 1st December 2016, the respondent was absent in the course of the inquiry. In the meantime, he addressed a letter to the Lieutenant Governor seeking a change of inquiry authority on the ground of biasness. On 15 December 2016, the Administration Union Territory issued a communication regarding that the Lieutenant Governor as a disciplinary authority rejected the representation of the respondent alleging bias against the inquiry officer. On December 2016, the administration wrote to the inquiry authority seeking date to the proceedings in view of the prior extension which had been granted by this court. On 18th January 2017, the inquiry fixed on 31st January 2017. On 2nd March 2017, the respondent was absent in the course of inquiry. The respondent was again absent on 4th May 2017 and a request by the inquiry be adjourned. The proceeding thereafter took place before the inquiry officer on 15 June 2017. On 20th June 2017, the inquiry officer posting in Union Territory. On 5th July 2017, another inquiry officer appointed. On 13th July 2017, the inquiry officer noted the reference to the inspection of documents that the respondent simply intimated on 8th July 2017 that he would be available for inspection of documents and a hearing after 16th July 2017. On 22nd September 2017, the respondent was absent and was accordingly granted an option to cross-examine PW7 by sending in a questionnaire. We have referred to some of the aspects of the records because they indicate that while some delay occurred in course of disposition as a result of change in the inquiry officer, equally it is evident that the respondent did not himself cooperate in the disposal of the disciplinary proceedings. In this background, it would be inappropriate allow situation or consequences while the disciplinary inquiry stands stultified. The respondent did not cooperate in the earlier conclusion of inquiries to accept the contention. The disciplinary must now ipso facto stand quashed will result in miscarriage of justice. In the fairness of Calcutta High Court, it must be appreciated that it was constrained by the fact that the extension was granted by this court. This is, however, not constrain the jurisdiction of this court to extend time even after it come to an end. This is not a case where an inquiry lapse under the service rules. On contrary, the rules emphasize that the inquiry which was being initiated prior to supervision can continue and conclude thereafter. We therefore incline to grant an extension of time to conclude the inquiry by recalling and modifying the order. At the same time, we must also take note of the grievances of the respondent, which as put forth by the Ms. Sajid Samantha, Learned Counsel, the respondent would be hardship consequent upon the fact that the inquiry was concluded after 14th May 2018 without the respondents availing his right to defend the charges. While we have remediate the situation by deciding the extent time for conclusion receiving proceeding. Equally, the order of this court should be deprive the respondent of opportunity to participate in disciplinary proceedings. We hence direct in exercise of jurisdiction and conferred under 142 of the Constitution that the inquiry proceeding shall be restored to the position immediately before 14th May and shall take forward from the stage. Accordingly, we issue the following direction. In modification of the order dated 14th May 2008, part is extended time for conclusion of disciplinary proceedings by period of 18 months ending on 31st July 2021. The administration of Union Territory Andaman and Nicobar Islands shall ensure that if the inquiry officer was appointed for inquiry is not available, a fresh inquiry officer shall be appointed within a period of 4 weeks from date of receipt of a certified copy of this order. The disciplinary proceedings shall be continued from the stage which has been reached immediately prior to passing of this order. This court dated 14th May 2018. As a consequence, within bracket Roman 3 about the steps which have been taken by the order of this court 14th May 2018 for concluding receiving as set aside the liberty to the administration of the Andaman Administration Island to conclude the disciplinary proceeding from this stage which has been reached immediately prior to passing of the order. 14th May 2018 is in accordance with the law. The response will cooperate in the disciplinary inquiries. If he failed to do so, the administration has liberty to proceed in accordance with the law. Now, this is after that doors have been closed, so this Honorable Supreme Court has made certain riders and the opened the disciplinary proceedings. But the disciplinary proceedings have been not concluded within that stipulated time allowed has been given by the Honorable
31st July.
31st July 2021. We approached the Supreme Court 115. That this is the order of the Supreme Court, which is the contempt has been dismissed and the miscellaneous application was allowed.
Hmm.
This is page number 460 mil. 460.
Hmm.
The time which is prescribed by the Honorable Supreme Court in that
Second volume is there? Yes.
four six zero.
How many volumes are there?
Three volumes.
Give us.
This is last volume, 460. Not got it, Miller? There is an order passed by the Honorable Supreme Court dated 31st January 2022, Miller, an application for extension of time. The last paragraph, para number 3. Having regard to the extension is already been granted previously, last and final extension is granted until 15th May 2022.
Yes.
But Lordship would also be pleased to look at paragraph 2, the reason for that. It was only for the purpose of consulting the UPSC. That is the reason why this extension was granted. Kindly keep a note of that, my lord.
Yes.
Lord, it says the cutoff period is 15th May 2022. Lord, we have to conclude within 15th May 2022. Lord, it is during that period when the inquiry has not been concluded, we filed again an extension before the Honorable Supreme Court. Lord, it is at page 461. Lord, it is as 1st September 2023. 1st September 2023, the matter was called for hearing today. 1st September 2023. Unregistered, last paragraph, my lord, unregistered version application is allowed to be withdrawn in the letter dated 24 May 2023. Now it is been withdrawn on 24th May 2023.
No.
Yes, yes, my lord.
It's withdrawn on 1/9/2023.
1/9 on 2023, my lord. 2023.
Actually,
Prior
this
to
was
the
extension, they sought an extension
Yeah, fine.
after the last one, and then withdrew it. That's it.
within the time frame it's approached before Supreme Court, my lord, it is not been listed. But why the withdrawal in the sense, kindly come to the order part which is passed by the Honorable President of India, my lord, which is at page number.
Who is this letter?
Madam?
24/5/2023 letter.
But the letter of 24 is not being enclosed because the punishment order was passed on August 2022. So the application which is filed for extension time become infected because the orders already came into existence. So no further extension is permissible because as on 2022 August, the punishment order passed by the President of India has came into existence.
Punishment order date?
Yes, I'm just giving the dates.
Lordship comes back to page 40, the dates are there.
Yeah.
Index, we have given the list of dates also. The volumes.
What is this letter the Honorable Supreme Court is referring to? 24/5/2023.
They wanted to withdraw,
Withdrawn, I suppose
They
it's a
want
letter
to withdraw.
because it's become infectious. So that
thinking,
will be the letter.
thinking that the order passed by the president at a particular date after the cutoff date of Honorable Supreme Court, that has given a benefit that we don't have to extend the time. That was the idea. No, that is a wrong concept totally, because they cannot extend the time like that by filing and then withdrawing it.
No, it is at page 325, minute. 325, minute. I think it's the last volume. 325. But I'll just take notes to the operative part. Not page number 9, minute.
Internal.
Internal page number 9. Running page 333, minute. Permitted to read from para 2, minute. Whereas the administration by letter 6 June 2022 informed on the receipt of the reply dated 20th June of the charge officer, the matter has been examined by the Honorable Lieutenant. He requested MHO to adhere to the advice of UPSC. Whereas after considering the facts of the case, contention of charge officer IO reported dated 10th May 2025 and advice of UPSC, it is observed the charge officer failed to obtain administrative approval and expenditure sanction from the competent authority before resorting to purchase of item, buying items on much higher price than the approved rate, causing pecuniary loss to the government exchequer. Thus, the CEO willfully violated the extant rules, procedures in the purchase of the items. The charge of unauthorized leave taken by the charge officer of period of 1/4/2015 to 24/10/2015 has been proved. And it is also proved that he failed to hand over the files related to tender for the procurement of pathological lab equipment In fact, the charge officer himself admitted that he handed over the files on 28/10/2015 in the interest of government. In the interest of government work, it was duty of the charge officer to hand over the files to the appropriate authorities officials before proceeding on leave. Thus, all the charges levied against the charge officer by charge sheet dated 2nd March 2016 have been proved. It is evident that the CO exhibited lack of absolute integrity and acted in the manner and becoming a government servant and violated the rules 3(1) within bracket 2 within bracket Roman 2 and within bracket Roman 3 of CCS Conduct Rules 1964. Now, therefore, the President, after considering the evidence and the facts on the record, circumstance of the receiving proceedings and the examination of representation of charge officer, and the advice of the UPSC has decided by virtue of the power vested under Rule 8 of CCS Pension Rules 2021, notified by GSR number 868 dated 2021 is accepted. The advice of the UPSC and imposed the penalty of withholding 20% of the monthly pension, otherwise admissible, to Dr. R. Tulsidasan, CMO, retired in the UT administration for a period of 2 years. The gratuity admissible to be may be released if not required, withheld for another purpose. But the President of India, through the Ministry of Home Affairs, has imposed a punishment order that the pension, it has to be decided of pension 2 years, 20% of the monthly pension has to be deducted for 2 years. 2 years. This is with regard to one proceedings, my lord. There are other proceedings. Lord, the other proceedings, which is order passed by the president, there are two disciplinary proceedings running simultaneously. That 397. Lord. My lord, this operative part, I take my lord's running page number 400, last paragraph. My lord. Whereas after, may I read it, madam? Whereas after considering the facts of the case, the IU report dated 15/4/2020, discipline authority disengagement order number 133 dated 3rd June 2021, charge officer reply thereon dated 21st June 2021, paraphrase comments of the DA on the reply of the CO, the advice of the UPSC dated 27 May 2022, and the representation dated 19 May 2020 of the CO thereon. It is observed that the intimation letter dated 30th 10/1997 and 13th February 1998 and 23rd August 2004 regarding acquisition of properties claimed to have been submitted by the CO, where only photocopies of the original copies were not available in the personal file. Moreover, these photocopies letter did not bear any diary numbers. Further, during the CBI investigation, charge officer not made any plea regarding submission of these letters, and the same was brought up by the CO only during departmental inquiry at the later stage. Thus, the charge levies against the CO under Article 1 of the charge sheet dated 4th March 2015 pertaining to the fraudulently inserting his personal files the photocopies of three fictitious intimations letters dated 30/10/1997 and 13/2/1998 and 23rd August 2004 regarding acquisition of property stands proved. It is evident that charge officer has acted in a manner which is unbecoming a government servant in contravention of rules 3(1) within bracket Roman 1 and within bracket Roman 3 Rule 18 of CCS Conduct Rules 1964. Now, therefore, the undersigned is decided by virtue of power vested under Rule 8 of CCS Pension Rules.
Where are you reading from?
Page number 400, Mala, running page number 400.
It must be in the other, is it in the other volume?
Yes, yes. I'm sorry.
Oh,
Now therefore, the undersigned has decided by virtue of power vested under Rule 8 of CCS Pension Rules 2021, right, with Rule 2 of CCS Pension Amendment Rules 2022 to impose the penalty of withholding 30% of the monthly pension otherwise admissible to the CEO for a period of 3 years. Further, the gratuity admissible to him may be released if not required to be withheld for any other purpose. Further, it is also mentioned that the above penalty will be applicable over and above the penalty of withholding 20% of the monthly pension for a period of 2 years already imposed on CEO-wide Ministry's Order Number 23rd August 20 in another proceeding case initiated via memo dated 2nd March 2016. Lord, there are two punishments, both has to be and simultaneously this is a punishment. My Lord, I just trouble my lords to kind attention towards page number 402. Lord, page number 402, my lord. The office report, because my lord, we have filed an application of extension within on 14th May 2022. It is submitted to Mrs. Second paragraph, my lord. It is submitted to Mrs. Samir Ali Khan. The advocate had on 14th May 2022 filed an application for extension of time, which was defective for various reasons, and the council asked to cure the defects of registry dated 24th May 2023. The instead of curing defects, will also file a letter. Withdrawal of the miscellaneous copy is attached herewith for ready reference of the court. The letter for withdrawal of misapplication is above mentioned before the registrar court of withdrawal dated 29th August 2023. Lord, the punishment orders was passed on first 23rd August 2023, 22, my lord, and the extension was filed before the Supreme Court within the time. But the matter when it reaches to the registrar on 20, as my lord is asking me also the letter with regard to 24th May 2023, based on which my lord the matter when it came to listed on 1st of September 2023, because already the punishment order has been passed, so it become infectious. So that as it become infectious, it has been not pressed, my lord. So this is my first submission, my lord. The other submission is that, my lord, the tribunal, while adjudicating the issue, I just take my lords to the order passed by the tribunal. Which is at page number 22, my lord, it starts. Page number 21, it starts, my lord.
page, volume 1.
Volume 1, my lord. Annexure P1.
Page.
No, I don't trouble my lords to the entire orders because already I have what I read before the Supreme Court's order that has been enumerated by the High Court tribunal also. My lord, I just take my lord's kind attention towards page number 28, inner page 8, my lord.
Oh.
I just make the I, my lord, I suppose it is I. The submissions of the applicant, learned counsel of applicant submitted the communication of Deputy Secretary Government of India Ministry of Home Affairs by letter dated 23rd August and 24 were forwarded by the assistant to the appellant while letter 21/10/2022 and 4/1/2023 respectively by imposing a punishment withholding 30% of the monthly pension for a period of 3 years with release of the gratuity in first departmental proceedings, withholding 20% of the monthly pension for the period of 2 years with the release of gratuity in second departmental proceeding against the applicant. According to the learned counsel for the applicant was not given provisional pension after February 2023. Therefore, his grievance may be considered by the bench at the earliest. As per the learned counsel for the applicant, the law is well settled that when a time frame for completion of disciplinary proceeding is contained in judicial order, The authorities are precluded from proceeding with the dispute proceedings after a lapse of time and the dispute proceeding abated after the set time limit. In support of his contention, learned counsel has cited the judgment of three judges constitutional bench in Controller and Audit General of India versus S.K. Jagannathan AR 1987 Supreme Court 537 and prayed for appropriate relief. Learned counsel of the respondent has filed a written reply denying the claims of the applicant. Relying on the reply, learned counsel respondent has placed the following manner. The applicant was charged sheeted in two departmental cases by the Lieutenant Governor of Andaman and Nicobar Islands for tampering and forgery of records for memorandum dated 4th March 2015 and also purchasing of lab pathological equipment for Dr. R.P. Hospital, Mayabandar and attached PHC and CLC North and Middle Andaman and the District Health Society North and Middle Andaman of NRHM, while memorandum dated 2 March 2016. During the pendency of these two departments, the applicant was not considered for motion. Therefore, he approached to the tribunal. Subsequently, the matter is up to Supreme Court. It is stated by the London Council respondent that after the passing of the aforesaid order, Supreme Court dated 29 March 2016, SLP number 7202 of 2016, SLP 7547 of 2016. Extension of time was granted by the Honorable Supreme Court complying with the order from time to time on prior administration on the ground of several procedure requirements. Finally, by order dated 31/1/2022 in IA 1559 of 42/2021. The time for conclusion of the proceeding against the applicant was extended as a last chance till 15th May 2022. During the course of argument, learned counsel for the respondent repeatedly argued that two department proceedings against the applicants were to be concluded as per Rule 9 of CCS Pension Rules 2020, which confers the power of withholding pension or gratuity only by the president. The direction on the completion of receiving was only on the Lieutenant Governor of Andaman and Nicobar administration. As per the learned counsel of the respondent, the applicant has drawn provisional pension with effect from 2016 to February 2023 and therefore no provisional pension could be sanctioned by the department as per the rules. Learned counsel for the respondent has submitted that as per the rules 8.3 of CCS pension, the provisional pension can only be issued any retirement government if the department of disciplinary proceeding is pending against him. As the department proceeding against the applicant were complete, he was entitled for regular pension soon after the completion of department proceeding. It is further stated that the department is proposed to implement penalty order against the applicant with effect from March 2023 onwards. But due to non-submission of requisite documents and non-cooperation of the part of applicant, the department could not process for payment of regular pension with effect from March 2023 and could not implement the penalty order of the Honorable President. Learned counsel for the respondent also submitted that the department has acted in a fair and transparent manner in accordance with the directions of the Honorable Supreme Court. Therefore, the OA is not tenable. We heard the learned counsel of the both sides, perused and places on record. Facts which are crystallized from the above are as follows. After following several litigation before the tribunal and also the Honorable High Court, the matter finally reached to Supreme Court. Honorable Supreme Court in SLP number 7202 of 2016 and SLP number 7547 of 2016 has passed an order dated 29th March 2016. Relevant portion which has reproduced below. Now that is as I pointed out, not that has been reproduced. Now page number 12 within bracket Roman 2 million. The administration has prayed for extension. The administration has prayed for extension further time to implement the above order. Such extension time was granted on the Supreme Court on 4 occasions. Thereafter, the Supreme Court rejected the prior of extension to further time. When the orders of Supreme Court has not been complied with even after opportunities granted to respond, apply filed a content application, diary number so and so, and administration filed an MA so and so special leave for recording modification order, which was disposed by the order dated approximately by modifying the previous order and direction conclude discipline within 8 months, ending on 31st July 2021. Relevant portion, the tribunal has quoted the contempt order, whereby Honorable Supreme Court has passed. Roman 3, page number 14, inner page number 14, running page number 34. Again, the Andaman Nicobar administration prayed for further time to comply with the order dated 13/12/20, but the prayer was rejected by Supreme Court on 31st/1/2020 by giving a last chance to comply with the order till 15/5/2025. Here I would pause for a moment. I showed the order, but the Honorable Court has said it being as a last and final charge, it has not been rejected. It is extended up to 15th May 2022. But the tribunal said it was the prior was rejected by the Honorable Court, and by giving a last chance to comply with the order till 15 May 2020, which read as follows. Roman 4, my lord. It is noted the punishment order on two disciplinary proceedings against were passed on 23rd August 2022 and 25/11/2022. That after the last date of 15th May as stipulated by the apex court. As per learned cause applicant, Supreme Court has granted last chance for completion of two disciplinary proceedings till 15 May 2022. Therefore, any order passed in such proceeding after the time will stand abated automatically. If I submit the punishment order dated 23rd August 2022 and 25/11/2020, which was passed after the last date, that is 15th May 2020, as stipulated by apex court, died in natural death. Therefore, the applicant is entitled to horse service benefits, including promotion, in terms of the initial order dated 23rd 29th March 2006, passed by the Supreme Court. As a above learned counsel, the respondent tried to apprise the court repeatedly that two DPC against were completed as per Rule 9 of CCS Pension Rules 2021, and administration nothing to do in this matter, though the Honorable Supreme Court has given direction to complete the discipline with the Lieutenant Governor of Andaman Nicobar administration within 3 months and extended time limit up to 15/5/2022, order dated 31/2022. Such contentious assessment has no legs to stand because the direction of Supreme Court was to complete the disciplines against the applicant within 3 months, which was not done. The respondents cannot deny the responsibility of completing disciplinary proceeding by taking advantage of Rule 9 of CCS Pension Rules 2020 because they had repeatedly prayed for and were granted extension to comply with the order of the apex court. It reveals from the record that the respondent and the present lawyer themselves have prayed for withdrawal for extension time, which was granted by the Honorable Supreme Court dated 1st of 2000, said order was read as under. Therefore, the respondent is barred by the principle of estoppel and cannot take any ground of delay in completion of receiving after 15/5/2022 as stipulated by the Supreme Court order dated 31/1/2022. In view of the foregoing discussions of way is allowed, the punishment order dated are hereby quashed and set aside. The respondent directed to release all consequential benefit, including the pension benefit to the applicant within a period of 3 months from the date of receipt of this order. The respondent shall pay interest to the petitioner's applicant at the current GPF rate from 16th May 2022 till the date of actual payment. Now, the Supreme Court has said, as the Honorable Tribunal has said, as a deadline was given on 15 May 2022, which has not been concluded within that particular time. So, the disciplinary proceeding both has been abated. My lord, and this my three submissions before this Honorable Court, my lord. The first instance, I admit that the Honorable Supreme Court has given a deadline with regard to 15 May 2022. On 14th May 2022, prior to that, we approached the Supreme Court for extension of time. My lord, the conduct of the respondent may also be seen. If my lord will see the order passed by the disciplinary being the President of India, because my lord, our powers being a local administration, confined to conduct and report, submit to the President of India. Whether we have conducted a report within the timeline stipulated by the Honorable Supreme Court or not. It is a clear case that we have done within the stipulated period of time. And we have sent to the ministry, that is, it has to be through the President of India for giving punishment. My lord, I understand because as my lord, I have shown several orders of the Supreme Court also, where the Supreme Court has specifically observed that the respondent has also made the delay in tactics to conclude with the disciplinary proceedings. That's why the Supreme Court has in the contempt order specifically said what are the events why the disciplinary proceeding has been delayed. Lord, in the instant case also, my lord, the order passed by the Honorable President was on 23rd August 2022 and the second order was on November 2022. Lord, if he could say that the order passed by both is being abated, he could have immediately approached to the tribunal. He has not done, my lord. 2023, 24, after 2 years, because we are issuing notices to him, because we have to comply with the responsibilities of India. We have to issue notice. See, the order, punishment order has been passed. We have to finalize your pensions. And we have to deduct the 20% as well as 30% from the pension orders. So he has not done down for 2 years. He has not submitted any documents for the 2 years. When on November, we issued a notice he completed the punishment orders, then he approached before the tribunal after a period of 2 years. Lord, I understand when the extension was filed, it was within time, but on 3, when the extension was listed on 1st September 2023, because prior to that, already punishment orders came into existence. So that the extension which is filed, it is automatically infectious because the purpose will not be granted because all punishment orders came into existence. So this is what I respect the submission by the Honorable Supreme Court. In the contempt order, which is specifically mentioned, the disciplinary proceeding cannot be turned on in a abated manner because the other aspect, other circumstances, the other events has to be taken into consideration. My lord, here we have not done anything against the delay administration to say that they use prejudice. I brought in orders passed by the Supreme Court. That is, we do accept the orders passed by the Supreme Court. We have accepted because when discipline proceeding delay tactics, the matter has to be reached to the MHA, then it has to be go to UPSC, then the observation of UPSC has to be communicated to the person, the charge sheeting officer, then he has to submit. Then it has to again go to the MHA, then the MHA has to take a call and pass an order.
Where is the inquiry report?
Lord, Lord, there are 195 was one inquiry report, Lord.
Yes.
No, the report first with the fine. जो लिखा अप्रैल में जमा किया बोलता है ना वो लेटर है जो अप्रैल में जमा किया बोलता है ना लिस्ट ऑफ डेट्स में ये है ना 24 and compress on the summary बोल रहे केस तब फैल तब बेचा ये 24 टूवर्ड्स है compress on the summary decision within time में मतलब in D ये लेटर है 24 टूवर्ड on the decision but that is a letter dated 24/12/2021 whereby in compliance with the Honorable Supreme Court's order the report was forwarded to the ministry received by the MHA on 24/12/2021 but I find नहीं गया आपका और inquiry report both the inquiry report में दोनों inquiry report में I'm sorry my lord just 2 minutes inquiry report और letter बताइए ये inquiry report है first 141 दूसरा वाला
While my learned friend is showing your lordship, just lordship looks once because there was an interim order passed by the learned tribunal that was challenged by before this honorable court. That my lord is at page, my lord. Just looks once, my lord.
But this is
Third volume.
117 and 141.
Third volume, my lord.
Page.
Page, my lord. 464.
Not they have, the tribunal is told to give the provisional pension.
Just a minute, let my lords look into the order.
We challenge that provisional pension order.
Their conduct and the this order stares them in the face. After this, Lord, they did not go to the Supreme Court.
See, but this is with regard to the matter was
Maybe.
adjudicated, but as court has said in view of the above, para 6, we do not find any reason to interfere with the interim measures. It was filed the returnable date and another terminal is with the felt to the authority to have acted upon. Because as the order of interim measures has been passed to release the pension, the provisional pension that we have challenged. The court has said already the tribunal has adjudicated the issue and as going to pronounce a judgment, I said they will not interfere with the order. So this is to that extent only. Lord, as Milord is asking me about the inquiry report, this is 117 and 141.
100?
117, Milord.
Yes, dated
13/4/2021, Milord. And this 140 is the part, Milord. 140
140.
conclusion. 140, Milord.
The second one.
First one, Milord. 140, as Milord is asking me the date.
Mhm.
So, Milord, 140, that was on 13/4/2021.
Okay.
The second inquiry report is at starts 141. Last page is 54, inner page 194, 10th May 2021.
Okay.
But this is my respectful submissions, my lord. The tribunal has not gone into this aspect and I pray the order has to be set aside.
It has not gone into which aspect?
My lord. But the tribunal has not considered that aspect, my lord, because
Which aspect?
regarding that, my lord, we have filed an extension, my lord.
Why
within
did you
the-
withdraw it?
My lord, as it was infectious on 1st September 2020, because the punishment orders came into existence on 22nd September 2022, my lord. The 22nd of this is August 2022.
Two orders came, one in August, one
One in November, my lord, on 2022.
2020.
Yes, my lord. The matter
And the
was
final extension was 15th.
that 15th May 2022. Not as, my lord, within the time we stipulated, we approached the Supreme Court.
Yes, that you have approached before the Supreme Court.
Yes, my lord.
You did not rectify the defects.
Yes, my lord.
And when it came up again on 31/1/2022, you withdrew it.
No, when it was listed, because withdraw become infectious, that is, it has been withdrawn. Because already punishment orders passed on 22nd September, August. So the question of that extension become infectious, as such, it has been withdrawn, being not pressed. This is
We
my,
have read the order of 31/1/2022 of the Supreme Court.
not
When
the
you withdrew that
15th May.
extension, when you withdrew the extension application.
No, when the matter is listed on 1st September, as such, it is being withdrawn because it's infectious, because the
When you withdrew that application for extension, were you aware of the order of 31/1/2022?
that is regarding the 15th May 2022 cut-off order.
I'm great.
That's all.
That was aware, that is aware. This is my respectful submission. I'm grateful. What are the records I brought on to the lordships I place before you?
They didn't
But
pay my
is that-
provisional pension. Ultimately, this court passed an order last before the puja vacation that you make payment for 2.5 years. They were just not making payment of anything, not a single farthing. Ultimately, the court came down upon them. My learned friend was there. They paid the provisional pension.
Lord,
That
the
too.
aspect is because the punishment was in 2022, but 23, 24, we are issuing letters to implement the punishment order. He is not turning back. When finally, when issued a final order saying that on November last, when intimation was given, he straight away approached to the tribunal. So this 2 years also, he also not approached, my lord. I understand where is what is the cut-off given by the 15th May 2022 by the Supreme Court, because the May extension was filed. It could have been pressed, or rather, it could have been observed the part of the punishment orders, then the matter could have been otherwise.
Before the tribunal, that he is approaching after 2 years.
Yes, my lord, everything was on place before the tribunal, my lord.
No, but
That we have approached, we have mentioned that fact to the tribunal.
they had
Lord,
taken that point that was dealt with also.
Lord, I respectful submission is what the disciplinary proceedings, that to be an officer who is, because the tribunal in first, second occasion when the Supreme Court has said it cannot be turned on in such a manner, because it should be looked into all the aspects. Not the instant case, the authorities concerned being an administration, we have concluded within time bound. But it is referred to the president because he is a competent authority. President has to pass an order. That passing of an order takes 3 months time because with consultation UPSC. So that such there was a delay. Otherwise, there was no intentional delay to dragging the issues. So this was the view of the authorities, and we have placed it before the tribunal also. As the tribunal has stricter sense in order to the Supreme Court's order, they have made it that 15th May 2020 is a cutoff, and as such, you cannot be proceed further to that. As the tribunal has rejected our applications. My humble submission is that the other aspect should have been looked into consideration that the tribunal has not done. This is my humble submission. Compliance.
Do I need to make any submission, Lord? Because it's very simple. The short point, Lord, is whether the authorities could proceed after the order of the Honorable Supreme Court granting a last chance. That was, Lord, page 386, where your Lordship has noted it, Lord, in your Lordship's note, where I showed your Lordship paragraph 2. What was the reason why the extension was granted? Page 386. An extension of time to conclude the disciplinary proceedings. He states that the inquiry has been completed and necessary formalities of consulting the UPSC have to be completed.
Mine is 460.
But it may be a second time it has been put in, maybe.
Yes.
Right. So, Lord, That was for consulting the UPSC. Now, if your lordship sees the list of dates, your lordship will see when they consulted the UPSC. Your lordship kindly comes to page 42, my lord. My lord looks at, I'm sorry,
Yes.
31/1/2022 is the order of the Honorable Supreme Court, serial number 4 of the IL number so and so for extension, last and final extension granted till 15/5. On 14/5, IA, that other IA is filed, which was subsequently withdrawn. Now, my lord, 4/7 UPSC advises. Admittedly, after 15/5/2022.
I think below that letter of 25th 7th May 2022, sir.
Hmm.
I think 27th May 2022 UPSC advice letter.
27/5 and 19/5.
Not on April.
Hmm.
July.
The date.
July, sir is saying about 4 July, sir. That's why.
So everything after date of 15/5/2022.
When did you put up before the UPSC?
Not as.
This is why I was asking you about when was the inquiry report.
But it has been put up. May kindly come to.
First, you'll have to put up before the MHA,
Yes,
isn't
yes.
it? When did you put up before the MHA?
So
After
it is
the inquiry?
24/12/2021.
Huh?
24/12/2021. Lord, the list of dates we have prepared at page number D, my lord. This is the first starting page. Capital D, my lord. In the writ petition, my lord, the list of dates of the writ petition.
Page 40, isn't it?
No, my lord, first one in the writ petition,
Oh,
D, my lord, list of dates.
okay.
Left hand side, this 24/12/2021. Document received by the MHA on 24/12/2021.
And my lord, what is more important, my lord, that in paragraph 21, page 13, they have said this, my lord. Page 13 of the petition, my lord, volume 1. It is to be appreciated that the direction of Honorable Supreme Court is only upon the Andaman and Nicobar administration to complete the disciplinary proceeding inquiry in its part jurisdiction, which was fully complied by the Andaman administration within time limit. Depending upon the outcome of the disciplinary proceedings and the final order had to be passed by the MHA, there is no time limit set by the Honorable Supreme Court. This is not wrong because not all were parties to the proceeding. Your Lordship will see the document, a Gmail was sent to us where the cause title is given. I don't have my copy. I have given both my copies to my lord.
That is with regard to.
Lordship sees the names of the parties there.
First SLP number.
No. Extension of time, the last one. All were parties.
Which one? Is there a lot of question?
This was their extension application where the names of all the parties have been shown. I'm grateful. Anything else, my lord, I need to submit subject to my lord's pleasure. Only one thing, my lord. The order should be complied with because I have not been paid only provisional pension. They have to pay everything, all consequential benefits. And the order is such by the learned tribunal. Lordship will pass that order within the time frame, subject to my lord's pleasure. I am grateful to your lordships.
But so. For the appellant, as well as so for the respondent. Hearing concluded, investment will.
Right.
Mr. Rakesh Kumar had come later on, but I had done the matter from the very beginning.
I just last
I was-
I will handle with this matter. I'm grateful and my Lord has given me patience listening to this. Right.
I am grateful.
Right.
Just copy it.
Item number 7.
Lordship, in this matter, I am appealing for the appellant. Lordship, this matter may be fixed on 26th of this month. But the senior counsel will be appeared on fiscal policy.
On request made by the land council. 26.
Number 8. Payment is 30 of 2025.
And for the appellant. Ma'am, for the respondent, my lord, I have received the paper book, my lord. Can be fixed on Monday for hearing.
On request made by land council for respondent.
For the respondent.
Monday is what? 24th.
Apply.
Oh, that matter is there. no?
Then application. Item 2.
Decision for the stay of the operation of the.
That's the- In that main application only, the intention. The impaired judgment decree date shown here, huh? Judgment dated 13/6/2025, passed by the learned district judge Andaman Nicobar and Port Blair. In other appeal number 13 of 2022. It's other appeal. Only that much. Shall remain suspended till the next sitting. Can is disposed.